I just want to give a shout out to the Goddard Riverside Law Project. Those materials here were developed along with them in the past and are based on some of their materials, so their good work is in here as well. So tonight we're going to talk about the different ways that you may arrange for somebody else to live in an apartment that you're the named tenant of. So we're going to talk about roommates, sublets, short-term rentals, and what are the differences legally between those things, and what does the law say about what we can do, what we're not supposed to do, what we have the right to do without asking anybody, what things the law says we have to get a landlord's agreement to do. So first, some definitions. So a tenant legally means somebody who has a right to live in the apartment, not just permission, but the right, because they have a lease or they have an oral agreement that they get not just to be there, but to have control of the apartment. And in exchange for something, usually rent, and for a certain period of time, though it could be as short as 30 days. So for rent stabilized tenants, that should always be a written lease. And it's always best if it's a written lease. But if you have those elements of the agreement, you are a tenant, even if it hasn't been put in writing. A roommate is somebody else who lives in the apartment, a household member, who's not a family member, but is living there, right? So not just a house guest. Someone who's there with the permission of the tenant, but usually not a legal agreement saying that they get to be there for a certain period of time. A co-tenant is someone else who has the same legal rights as the tenant. They're a tenant themselves, right? So that means somebody who actually is signing the lease. And a lot of times people use terms like, somebody's on the lease or somebody's named in the lease. I'm going to try to avoid those terms because they can be a bit confusing. Because sometimes leases will include a list of the other people in the apartment, but that's not the same thing as being a tenant. So I'm just going to try to be as clear as I can by talking about tenants who are signatories to the lease, and other people who might be listed somewhere, but who are not actually tenants. And then finally, a guest, right? So this is somebody who is staying for less than 30 days or 30 days exactly. But is not really living there and does not have any ongoing legal right to be there. Right. So with those definitions, let's move forward. Okay, there we go. Let's talk about roommates first. So people may have heard in New York, we have what everybody calls the roommate law. It's actually real property law, section 235F. It says that no matter what your lease says, a tenant always has the right to have their immediate family members live with them, any of their immediate family members' minor children. And if there's just one named tenant, one signatory to the lease, you also have the right to have one unrelated occupant, so a roommate, as well as that person's minor children. So the law provides for a floor. That is not the limit on what people can have. The roommate law says that if a lease says that you are not allowed to have those people live with you, that part of the lease is not enforceable. This is a minimum. If the lease doesn't say anything about who can and can't live with you, then there is no limit on who can and can't live with you. And I hear this all the time, even from lawyers, landlords, lawyers saying, "Oh, you're in violation of the roommate law because you have more than one unrelated occupant living with you. And the roommate law does not say that you can't have more than those people live with you. It says that you always have the right to have at least your immediate family members and one unrelated person and all of their minor children live with you. Beyond that, it depends on what your lease says. So if there is no limit in your lease, you can have as many people live with you up to the point where eventually housing code and health code limit the number of people who can live in an apartment by square footage. I'm not going to go into that because it's very, very rare that someone would get to that point. The roommate law gets a little bit more complicated and convoluted if there's more than one tenant of record, more than one signatory to the lease. So let's say there are two people who are both co-tenants. They both sign the lease. Every tenant has the right to have their immediate family members and those family members' minor children. But if there's more than one tenant of record, you cannot actually have additional unrelated people unless one of the tenants isn't there. And this is just not very clear. So I'll try to explain it a couple ways because this is one that even we lawyers have trouble wrapping our heads around. So if the lease just says one person, right? If my lease says Michael Grinthal is the tenant and I sign it, I can have my family and I can have one additional unrelated roommate. But if the lease says two people, it says Michael Grinthal and John Smith, and we're both tenants, both of us can have our family members, but we actually can't have any additional unrelated people staying with us unless one of us is out for some reason. So if John Smith has to go live in China for work for 6 months, and once then we can bring in a roommate to take his place. If this is hard to remember, that makes a lot of sense. It's not a very clearly written law, and it's kind of counterintuitive. But if you think about it as they are the legislature wanted to make sure that people could live with their families, and they wanted to guarantee that people could have roommates, but they were concerned that the more tenants of record you have, they don't want the number of people living in the apartment to just start expanding exponentially, right? So the more tenants there are, the fewer unrelated people can live with them. If folks have questions about that, absolutely, let's talk about it during the Q&A session. So if you have more people in the apartment than the lease allows and more than the roommate law guarantees, then that can be a basis for eviction because it's a breach of the lease. So again, that is only if the lease sets a limit on who can live in the apartment. That limit is greater than what the roommate law guarantees you, and you've gone above it, right? If your lease doesn't say anything about who can live with you, then there is no legal limit except, again, that the health code violations on how many people can live in an apartment, and it's extremely rare that anybody is that crowded. Okay, so now that I've made that perfectly unclear, I'm going to try and go forward. If you take one thing away from this, it's just that, first of all, no matter what, all tenants have the right to have their immediate family members and their immediate family members' children live with them, period. If there's only one named tenant on the lease, they also have the right to have one unrelated person and that person's children. So, for example, and this is a bit like what I was saying about myself and John Smith. So, if I'm the only tenant on the lease, Michael Grinthal, that means under the roommate law, no matter what my lease says, and if you look closely at most leases that are come on pre-printed forms, most of them say no one else is allowed to live with you, and that just hasn't been edited since the roommate law passed in the 80s. Uh, but even though it says that on the lease, that's void and not enforceable. And the roommate law specifically says that any part of a lease that violates the roommate law or that contradicts the roommate law is just a nullity. And not only that, any agreement by a tenant to waive any of your rights under the roommate law is automatically void. You can't accidentally give up these rights. Can't even give them up on purpose, although you can choose not to exercise them. So if I'm the only person who signs the lease, I can have my immediate family live with me. If any of them have minor children, they can live there too. And I can have one additional person who's not related to me, a roommate, and their children, right? I do want to mention that if you live in a special kind of housing, subsidized housing or program housing, like HASA or Section 8, public housing, Mitchell-Lama, low-income housing tax credit, the rules are different. In some of those, there are other limits on who can live there, especially if it's federally subsidized housing, because the federal law will override the state law. And so whatever the federal law says will apply. And in other kinds of program housing, you may not have to get permission to have people live with you, but very often in those kinds of housing, you have to report annually on the household composition and income. So those, if you live in those kinds of housing, there may be different rules that apply.
To see your aunts. That was crazy.
Yeah.
Yeah. I just can't always do great.
Whoop. So, okay, thank you. Um, it gets a little more complicated, as we discussed, if there's two tenants on the lease, right? If the lease says the tenants are Michael Grinthal and John Smith, me and John Smith can both have our immediate family live there. We can both have our immediate family's immediate minor children live there. But we don't get to have the unrelated occupant unless either me or Mr. Smith are not there. So if we're temporarily gone, right? If we've permanently left, that's another issue. And we may have given up our tenancy. But if for whatever reason we're away for a while, then we can have one unrelated occupant in there to kind of fill their place and so on. Again, for Section 8, Scree, Dree, Mitchell-Lama, there are other rules, right? You are often required to report or even get permission to have other household members there. Some common situations for Scree and Dree, the rent freeze program for rent stabilized and rent controlled tenants, all family members have to be included when you report the family composition and the household income. Roommates, unrelated people, they're not considered part of the household for Scree. You don't have to report them. But if you get income from charging them rent, that income counts, and you have to include that in reporting your income. As for Section 8 and Mitchell-Lama, they require you to report just everyone who's in the apartment and all of their income. And they have a lot of specific rules specific to that program about how you handle that. Okay, now you can charge roommates rent. In fact, that's the main reason most people have roommates, right? But there are limits on how much you can charge a roommate depending on what kind of apartment you live in. So if you live in an unregulated apartment, market rate, you can charge your roommate whatever you want and whatever they'll pay, unless there's something in your lease that says otherwise. If your rent's stabilized or rent controlled, you can only charge your roommate the proportionate share of the rent, right? Uh, so if you have one roommate, you can't charge them more than half the rent, right? If you have two roommates, you cannot charge each of them more than one third of the rent. Uh, Rent controlled, slightly different. Doesn't have to be proportionate, but you can't make a profit. You can't charge your roommate more than the total rent. And that what counts as a proportionate share of the rent can get a little complicated based on how many people live there. So how do you decide how many people there are when you're dividing it up and figuring it out? Uh, so First of all, you count the number of people named on the lease, right? Each of those count as one person for the purpose of dividing up the rent. Those family members of a tenant, they aren't included here, right? So if I've got three kids, uh, and then I have a roommate move in, it's still the roommate's paying 50% of the rent. I'm paying 50% of the rent. We don't count the kids in there. If my partner comes and lives, we don't count my partner unless they're a tenant in their own right. Okay. So this brings us to a really sensitive subject that's been and still is a subject of a lot of battles in New York, which is Airbnb and other kinds of short-term rentals. Short-term, first of all, in New York law means less than 30 days, right? So basic rule, it's illegal in New York City to rent an apartment, the whole apartment, for less than 30 days, period. No matter who you are, no matter what kind of apartment it is, you cannot rent out residential apartments for less than 30 days, right? Hotels can do that. Beds and breakfasts can do that. Other kinds of buildings can do that. But there are strict laws specifically to prevent scarce housing from being converted into Airbnb profit making enterprises, because there are a lot of landlords who will realize that if somebody's willing to pay $100 a night uh, to stay in an apartment through Airbnb, they can make a lot more money per month than if they rent it out to a tenant. And that would threaten very quickly to have a drastic effect on the amount of actual housing in New York City. We don't want most of our housing to be converted into essentially hotels. So there's strict limits on this. It is illegal in New York City to rent out an entire apartment for less than 30 days, period. If you are living in the apartment, you can have a roommate live with you and pay for less than 30 days. You can have a short-term roommate, in other words. As long as you are living there, it is not considered a short-term rental. But the last few years, there has been a law, Local Law 18, that says anybody who's going to host any kind of short-term paying occupant has to register with the city, right? So let's say you live in a two-bedroom apartment. You are the only tenant. You're the only person who lives there. You want to make you want some help with the rent. So you list your second apartment on Airbnb, right? And people come and they stay a couple nights. So you're not breaking the illegal hotel law. because you have not converted your apartment to a hotel. You're still living there. But you are still required to register with the city before you can uh, post any kind of short term offers for anybody to stay in your apartment. Second, you still have to charge them the proportional share of the rent, right? And it has to be prorated by the number of days. So, for example, if my rent is $2,000 a month and I'm going to have somebody stay in my second bedroom for 3 days, right? I can only charge them $100. Right? So they're paying half of the rent for 3 days, right? So they're paying half of the rent for 1/10 of a month, right? Which comes out to $100, right? If I charge them any more, even if it's less than half of my monthly rent, I'm overcharging them, right? Because they're not staying for a month, right? I have to prorate and charge only the proportional share of the rent. And if I don't do that, I can get in trouble in two possible ways. One is the person who I overcharged might be able to make a claim against me and get their money back and even be able to get additional damages. Second, housing court judges have kind of agreed on a new judge, not new at this point, actually, it's about 15 years old, created rule that says a rent stabilized tenant who repeatedly uses their apartment for profit by charging more than the proportional share is now using their apartment as a commercial enterprise. And that can be a basis for eviction, right? So it's important, if getting roommates, either short term or long term, to help with the rent, right? There are a number of laws in place, even if you don't remember the details of this, just to remember that anything that is profit making, there are a few laws against, and there are a number of different possible consequences, including possible eviction. Okay. So everything that we've talked about up until now is about roommates, other people who live in your apartment with your permission that you can take away at any time, right? Subletting is something different. Subletting is taking your tenancy, right? What you have bought the right to occupy and control your apartment for a certain period of time, a year or 2 years, in exchange for rent. Subletting is taking that and selling it to somebody else, right? So it means you're not living there, right? You've given them the apartment, the right to occupy the apartment in full, right? Which means you are not there, right? Not only that, but you don't even have the right to go back and stay there if you want because you've contracted it to somebody else, right? You are giving the subletter your right to be in the apartment. That is very different from a roommate, though landlords will often try to take the definition of subletting and expand it. And because the laws around subletting are stricter than the laws about roommates. So I've seen many, many times landlords bring housing court cases saying you've illegally sublet your apartment uh, when all they're really saying is you have somebody else living with you. If you sublet your lease, you still have a contract with the landlord that requires you to pay the rent, right? Your subletter should pay you the rent and you pay to the landlord. But if your subletter doesn't pay you, that doesn't excuse you. You still have to pay, the landlord. So that's one risk that you incur when you sublet. There are pretty detailed rules in the law about subletting. Um, so if your building has four or more apartments in it, or other kinds of residential units, you have a right to sublet the apartment, but you have to get written consent of the landlord. The landlords cannot unreasonably withhold consent. If you come to other of these workshops, you know, anytime you run into the word reasonable or unreasonable in the law, it means that people are going to go to court and fight over what's reasonable and unreasonable. Um, but the way that it's supposed to work, and the steps that are clearly outlined in the law, is first you need to tell the landlord you intend to sublet. And it actually requires that you mail them a letter by registered or certified mail. I think in practice, a lot of people just email and the landlord is cool with that, but technically you've got to do it by mail. Within 10 days of getting this, the landlord can ask for additional information. And that information is usually things like the name of the person you want to sublet to, financial information about them, uh, where they've lived before, things that allow the landlord to do the kinds of checks that they do with an applicant. If within 30 days the landlord hasn't given an answer, then, and it has to be a written answer, then that's an automatic yes. All right. So if the landlord doesn't respond in time after 30 days, they've consented whether they wanted to or not. Right. If the landlord replies within 30 days and says, I approve, then obviously they've given consent. If the landlord says no, but they haven't given a reason, then you're in an area where there might be a legal dispute. Because again, landlords are not supposed to withhold permission to sublet unreasonably. Um, and generally that means saying something like, I found something in this person's history that showed that, that it would be dangerous to have them in the building, or this person can't afford this place. Those might be in the realm of reasonable. If the landlord just says, I don't like this person, or I don't like the idea of you subletting, or, I'd really like you to find a subletter who, is would be a nicer addition to the community. Those are probably unreasonable. And what's reasonable and unreasonable, it's kind of come together through years and years and years of people fighting about it in court and judges saying, oh, making decisions and putting all those decisions together. So if you're in this position where you want to sublet and you've gone through this process and the landlord has said no, and you think that may be unreasonable, there's not much of a shortcut or a simplified rule here. It's a good idea to find somebody with some experience that you can talk to, a lawyer if you can. Talk to the folks at Cooper Square Committee. They themselves, first of all, have a lot of experience with different situations around landlords and their consent. They can also reach out to us and to other lawyers. And I usually hate just saying consult a lawyer, but the fact is there really is no simple rule that I can give that'll help you figure out whether it's risky to say to a landlord, I think that you're unreasonably withholding consent, so I'm going to go ahead and sublet my apartment, because you may very well wind up fighting out in court whether that was reasonable or not. And the risk, if you lose, could be that you are evicted. Uh, there are rules about what you can and can't charge subletters. You can't charge more than the rent. You can't make profit. But they do allow, if you're subletting the apartment fully furnished, so you're letting them, use your stuff as well as your apartment, you can add 10% to the rent. You can't sublet an apartment for more than 2 years at a time. Uh, and breaking these can lead to eviction, but also, just like tenants, if they're overcharged by their landlord, can bring a complaint to DHCR and get not only their money back, but maybe triple damages. Subletters have the same right with regards to tenants. So if I overcharge a subletter, they could take me to DHCR or to court, and maybe I might have to pay triple damages. Right? So, oops, I don't know if folks saw that, just a little screen glitch there. Um, so, generally, when sending that initial letter to the landlord saying, I would like to sublet, right? The information you want to include, and as always, we're going to share these slides so you don't have to get everything down here. How long you want to sublease for, the beginning date, the end date, who you want to sublet to, and some information about them, like what is their address, why you're subletting, where you're going while you're subletting. If there's anybody else on the lease or you have a guarantor, you have to make sure that you've gotten their consent. And if you're going to do a written agreement and you've got one, a copy of that as well. Those are good things to provide. If you don't provide them, the landlord's just going to ask you to provide them. And if you don't follow up with that, this can delay things, which can be a big problem. If you have someplace you have to get to, and you have a possible subletter who's not going to hang out forever while there's uncertainty. Now, you may hear or you may see in your lease the word assignment, right? So assignment is a different thing than sublet. It's actually fairly rare. To assign a lease is basically to give your lease to somebody else permanently, right? They're going to step in and be the tenant instead of you, and you're not coming back, right? Uh, there is no legal right to assign the lease without the landlord's agreement. And none of these rules about subletting apply to assignment. So landlords, when they rent to somebody, they can object to you replacing yourself with somebody else that they didn't uh, review or agree to have live there. A landlord might agree to it, and I assume this happens peacefully all the time, all over the city. But as a housing lawyer, I never see those cases. Uh, they must happen, but people only come to me when they're having a fight about something. Okay. So, if you a lot of a lot of this is kind of bewildering. Um, there's details within details, and then new rules that have sprung up through court cases that you can't find written down anywhere. So if you're going to take away three things from this, let them be this, right? The tenant always have the right to have their immediate family and their immediate family's children live with them. If there's only one tenant who signs the lease, you also have the right to an unrelated person and their kids. But you can't charge more than the proportional share of the rent, like their share of the rent. Right? You cannot sublet without written consent of the landlord, but the landlord is required they can't unreasonably withhold consent. Short-term rentals of entire apartments are illegal. Short-term rentals being less than 30 days. Um, Having short-term roommates or renting out one room in your apartment is allowed, but there is a lot of fine print, and it's not something you want to just post on Airbnb. You should check out. Uh, if you Google, it'll probably take you right to the mayor's office of special enforcement. That's the city agency that oversees the hotel law. It has pretty straightforward information there, including how you can register to do this. But again, if if you take only one thing away from this training about short-term rentals, it's never do it if you're not going to be there. And if you are going to be there, check what the rules are with the city and don't just go ahead and do it. And again, the results of that can be uh, the person you rent to might wind up with a claim against you. Your landlord might have a basis for eviction. And if you really break the illegal hotel law, it can actually even be a misdemeanor. Usually I have a lot of links at the end of these. I've only got one this time, but it is the DHCR's fact sheet about having other people in your household. It is actually pretty good and thorough fact sheet. And if you're rent stabilized, this is a good one-stop shop for the rules. And that's it. I hope that I've not made things too much worse in terms of trying to understand the law. But this is not one of the clearest parts of our law in New York City.